Welcome to Shorthand Study Classes. Get ready for freehand progressive shorthand dictation. Start. We would hold the true effect of section 10, bracket 2 and 3, read with section 14a, is as follows. Star. An application for ejectment of a tenant is to be made before the assistant collector under section 14a star. Such an application is to be decided after giving notice, and it is to be decided summarily star. Says the exclusive power to decide the application to evict the tenant has been conferred on the assistant collector. The lawgiver has further contemplated that after receipt of such an application by the assistant collector, no other court or authority is to proceed with any other relating to the same matter upon being informed by the assistant collector of the receipt of the application under section 14a star. What is more, such proceeding is to be lapse after a determination of the dispute by the assistant collector star. The lawgiver, no doubt, does contemplate an exclusive and expeditious remedy for the landlord to seek eviction, brooking no overlapping of jurisdiction by exercise of power by any other court or authority on a parallel basis. However, this provision cannot mean that when the very existence landlord-tenant relationship is brought under a cloud by the tenant raising a dispute, then the very premise on which the exclusive jurisdiction conferred on the assistant collector is not overturned. In other words, the lawgiver has proceeded on the basis that the assistant collector is clothed with the power to decide a matter relating to eviction in a summary fashion. This would be inconsistent with scenario where the very existence of the landlord-tenant relationship is disputed. The lawgiver, in other words, proceeds on an assumption that the application made by the landlord is against a person who is indeed the tenant. Para. We will, however, proceed on the basis that what is contemplated is that during the pendency of the proceeding before the assistant collector, even a suit in a civil court where the title of the landlord is questioned, or in other words, there is a challenge thrown to the very existence of the landlord-tenant relationship, is not contemplated. Even in such a scenario, after the conclusion of the proceeding in the light of the decisions of this court, starting with case bracket supra and Richpal Singh bracket supra, would apply, and the bar under section 25 would not be available. The civil court would have the power in a case where, without it being a frivolous challenge to the landlord-tenant relationship, in a genuine dispute relating to landlord-tenant relationship, the orders passed by the authorities under the Act can be found to be null and void for the reason that, transgressing the power conferred, the authorities proceed to decide the matter, which again, it must be remembered under section 10, bracket 2, is to be a summary decision, which is the vexed issue relating to the very existence of the landlord-tenant relationship. Para. The words used in section 25 of the Act, as already noticed, is that except in accordance with the provisions of the Act, the validity of any proceeding or order taken or made under the Act cannot be questioned in any court or before any other authority. In the dissenting opinion, Justice R.S. Sarkaria in Amar Singh and another bracket supra has explained the scope of the expression except in accordance with the provisions of the Act with reference to Section 24 of the Act star. In other words, an order passed under Section 14A could be challenged by way of an appeal, review and revision as provided in the Tenancy Act adverted to in Section 24 of the Act star. This explained the question perseverance or perseverance or perseverant, however, as to whether the validity of the proceeding or order passed is beyond the perseverant nature of the court under the circumstances analogous to that obtaining with reference to a proceeding under Section 14 or Section 77 of the Tenancy Act star. In other words, Section 77 of the Tenancy Act persevere or inter alia provided for seeking eviction or of a tenant before the revenue officer star. Section 14A of the Act similarly confers powers upon the revenue officer to entertain an application for evicting a tenant star. Para. The principles relating to exclusion of civil courts jurisdiction are well settled star. Ouster of the jurisdiction of the civil court is not readily inferred star. In the scheme of Tenancy Act also, an order under Section 77 could be subjected to appeal, review and revision as provided in the Act star. Section 77 Bracket 3 of the Tenancy Act purported to confer exclusive power on the revenue court to decide certain disputes and ousted jurisdiction of courts star. This included the proceeding to evict the tenant star. In other words, the civil court could not entertain the application to evict a tenant star. It is in this statutory framework that this court has stated the view that if a landlord-tenant relationship is disputed, despite the exclusive jurisdiction conferred on the revenue court to even order eviction of a tenant, the civil court would still retain jurisdiction in a case where there is a dispute relating to landlord-tenant relationship star. The Act was enacted in 1953 star. As noticed by us, Section 14A of the Act provided for the eviction of a tenant notwithstanding anything contained in any other law star. Therefore, apart from the fact that it became an exhaustive catalogue of circumstances entitling the landlord to launch proceedings for eviction and also further designating the statutory authority before which it could be filed, it provided for a bar to challenge the validity of the orders passed except by way of the remedies provided under the Tenancy Act star. There would not be any justification for revisiting the principle laid down that when the relationship between landlord and tenant is contested, the civil court continue to have the jurisdiction despite the bar under Section 25 of the Act star. We see no reason to hold that the validity of the order passed by the Assistant Collector as may be affirmed in appeal, review or revision cannot be questioned in a civil court if the expression validity is conflated with legality star. In other words, if an order is illegal, it would be invalid star. The illegality of an order can arise out of various causes star. An order may be illegal and therefore invalid on the ground that the author of the order, in this case, the authorities designated under Section 14A, did not have the power to decide the issue star. We are in this case concerned with illegality due to absence of power star. We are not called upon to decide the position where the authority under the Act violates the fundamental procedure relating to natural justice and the civil court is invited to sit in judgment over the same star. What we find, the expression validity of the decision or the order in section 25 of the Act would not include the case where, despite a dispute projected that there was no landlord-tenant relationship, the authority decides the said issue in the course of the order of eviction under section 14A after brushing aside the tenant's objection relating to his position with that he is not a tenant star. In such a situation, the validity is tied up with the fundamental aspect of absence of power of the authority to decide on the question of landlord-tenant relationship star. We must clarify, therefore, that the validity of the orders under Section 14A is open to scrutiny in a civil court in a situation where the tenant denies and disputes the case of the landlord and that a landlord-tenant relationship star. We must, however, further hold that a mere plea by the tenant should not lead without anything more to render